If you're married to a U.S. citizen, engaged to one, or even just thinking about starting a marriage-based green card case this year, you need to slow down and really listen for a few minutes. The way these cases are being reviewed now means that what worked smoothly even 2 or 3 years ago can lead to long delays, unexpected denials, or interviews that feel less like a friendly conversation and more like a high-pressure interrogation. The most worrying part is that most couples don't realize anything has shifted until they're already deep in the process. Facing a request for more evidence or walking out of an interview asking each other what just went wrong. Simply being legally married is no longer enough. A marriage certificate on its own doesn't protect you. Love doesn't protect you. Good intentions don't protect you. What matters now is how your relationship appears from the point of view of an immigration officer who is trained to assume nothing and verify everything. Under the current enforcement priorities moving into 2026, the level of scrutiny has gone up. Interviews are becoming almost universal, and even small inconsistencies are taken more seriously than before. Real couples, genuine, committed couples, are getting caught out not because their marriage is fake, but because they underestimated how closely their life would be examined. And if you think that once you're approved, you're completely safe, especially if you receive only a conditional green card, there's another phase you need to understand. In the next few minutes, I'm going to explain what has actually changed, what officers are paying closest attention to, and what you can do to protect your case before it turns into a stressful and expensive problem. Hi, I'm Timothy, and for years I've been explaining immigration rules in straightforward language so real families can see what is actually happening behind the scenes. I've watched how approval patterns, denials, and enforcement priorities change, including subtle shifts that don't always appear in the news but absolutely affect marriage-based cases. Right now, the marriage green card process is less forgiving than it used to be. I'll walk you through what's different in 2026, how the interview has evolved, what kinds of evidence really carry weight, which red flags trigger deeper scrutiny, and the mistakes even honest couples still tend to make. This isn't about scaring you. It's about getting ready. Once you understand the mindset of the officers reviewing your file, you can present your case in a way that protects your future instead of putting it at risk. Before we talk about what has changed, it's important to be clear on how a marriage-based green card is supposed to work in theory. When a U.S. citizen or lawful permanent resident marries a foreign national, they can file to sponsor that spouse for permanent residence. The green card then allows the foreign spouse to live and work in the United States on a long-term basis. But timing already matters at this first step more than most people realize. If your marriage is under 2 years old on the day the green card is approved, the government issues a conditional green card. That card is valid for only 2 years. Toward the end of that period, you have to file another petition together to remove the conditions and show that the marriage is still genuine and ongoing. If your marriage is already 2 years old or more when the case is approved, the foreign spouse usually receives a 10-year green card from the beginning. The process itself can move along two main paths. If the foreign spouse is already in the U.S. and qualifies, they can often apply to adjust status without leaving the country. If they are abroad, the case typically goes through consular processing at a U.S. embassy or consulate. Both paths involve forms, fees, background checks, fingerprints, a medical exam, supporting documents, and in almost all situations, an interview. On paper that sounds orderly. File the right forms, include your marriage certificate, attend the interview, wait for approval. But this is where many couples misjudge what they're dealing with. They see it as an exercise in filling out paperwork, when in reality the government views it as an investigation. That investigative mindset is exactly what has sharpened under the 2026 enforcement approach. Marriage-based petitions have always been looked at closely, but the level of suspicion has increased. Officers now receive more intensive training on detecting fraud in marriage cases because historically, fake marriages have been a common way people have tried to misuse the system. Instead of assuming a marriage is legitimate unless there is obvious proof otherwise, officers now operate much closer to prove-it mode for everything. One of the clearest signs of this is the interview. In the past, some couples were approved without ever being interviewed. You should no longer expect that. Interviews are now standard in most marriage cases, and they're not casual. They are structured, methodical, and often probing enough to feel uncomfortable. You may be questioned together or separated so your answers can be compared. Officers can ask how you met, who initiated the relationship, what your first date was like, how your home is set up, who sleeps where, who gets up first when your spouse leaves for work, what you did last weekend, which relatives you've met, and how you normally spend holidays. The aim isn't to embarrass you, it's to see whether your answers reflect a real shared daily life. Real couples build routines, memories, and patterns together. Officers listen for that natural overlap. One off answer will rarely ruin a case by itself. What raises concerns is a repeated pattern of answers that don't match or that sound vague where specifics would normally be expected. Many genuine couples trip up simply because they never reviewed their own applications or talked through their story beforehand. They trust that their love will be obvious. But this process doesn't measure emotion. It measures consistency and documentation. The higher level of scrutiny also shows up in how officers handle your paperwork. Requests for evidence are more frequent and more detailed. Basic or last-minute documentation no longer satisfies officers the way it might once have. They want to see that your lives are intertwined in multiple ways, financially, physically, socially, and across time. If your proof is thin, late, or looks staged, your case can slow down significantly or become difficult to recover. That leads to a crucial question. What kind of evidence actually persuades an officer, and what kind of evidence quietly makes them uneasy? A marriage certificate alone proves only that a legal ceremony took place. It does not prove that your relationship is real and ongoing. The government is not just asking whether you're married in a legal sense. It wants to know whether you actually live as a married couple. The strongest evidence usually shows shared responsibility and shared life over time. That includes things like leases or mortgages in both names, joint bank accounts that both of you actually use, health or life insurance listing. Each spouse is beneficiary, joint tax returns, utility bills. Listing both of you, car titles, travel records, and photos taken at different times and in different settings over months or years, not just one carefully staged day. Officers are trained to look for patterns and timing. If you opened a joint account a week before filing and there is almost no real activity on it, that can look artificial. If every picture you submit is clearly from one event, even if the clothes change, that can appear staged. They will also note when each piece of evidence began. Documents that grew naturally as your relationship developed carry more weight than items created suddenly just before filing. Social proof also matters. Do friends and relatives actually know you as a couple? Are there sworn statements, affidavits from people who can describe your relationship? Are there invitations, memberships, or celebrations that show you've been living as a couple for some time? Officers are trained to tell the difference between evidence born out of a lived relationship and evidence assembled just to support an application. No single document determines approval. Officers are looking at the alignment between your forms, your interview answers, and your supporting documents. When they reinforce each other naturally, cases usually move ahead more smoothly. When they clash or leave gaps, the case slows down and scrutiny intensifies. On top of that, certain factors, often called red flags, automatically make officers examine your case more closely. These do not automatically mean denial, but they change the way your file is read from the very beginning. Examples include a large age gap between spouses, a relationship that moved very quickly from first contact to marriage, big differences in education or finances, not sharing any common language well, significant cultural or religious differences, getting married soon after a visa overstay or status violation, or a relationship that was mostly long distance with relatively little time spent together in person. Each of those situations can absolutely describe an honest, loving couple. But those same patterns also show up in fraudulent cases, so officers are expected to look harder when they see them. It's not that one red flag automatically dooms a case. Problems arise when these risk factors appear and are not balanced by strong, consistent documentation. If you have a major age difference and very little joint evidence, or you married fast and have barely any shared life to show, or you cannot communicate well in the same language, and your answers in the interview don't line up, the combination of those facts can push your case into a higher risk category. At the core, officers are testing whether the relationship seems plausible when seen as a whole. Does it make sense? Do the documents and your answers back up your story? Couples who acknowledge what might raise questions and then document their situation clearly tend to do better than couples who pretend the issues don't exist. If an officer ultimately decides that the marriage was entered into mainly to get an immigration benefit, the consequences can be serious and long-lasting. A denial based on marriage fraud is not just try again later. It can lead to a permanent bar on receiving most immigration benefits in the future, and in some cases, removal proceedings. In extreme fraud cases, both spouses can face criminal consequences because marriage fraud is a federal crime. Most sincere couples will never find themselves at that extreme. But understanding what's at stake explains why officers take their job so seriously. In some particularly suspicious cases, review can extend past documents and interviews to unannounced home visits. Officers may visit to see whether both spouses actually live at the address on file, looking for everyday signs that two people share the space. Then there is the stage many couples think of as the finish line, getting the conditional green card. When that 2-year card is approved, it feels like you've made it. The interview is behind you, the notice of approval arrives, and the card is in your hand. Life feels settled. But a conditional green card is intentionally designed as a second checkpoint. It is not full permanent status yet. It's more like a built-in probation period. Around 90 days before the card expires, you're expected to file to remove the conditions. Many couples underestimate how important and demanding this second step has become. The processing time can be long. RFEs are common. Second interviews are being scheduled more often, even when the first approval went smoothly. And this time, the question is broader. Now, immigration isn't just asking whether your marriage started in good faith, but whether it has stayed that way. Everything that has happened during those 2 years is potentially relevant. Where you lived, how you managed finances, whether you filed your taxes jointly, how your responsibilities grew and changed. Some couples run into trouble at this stage because once the first approval came through, they stopped paying attention to documentation. They closed joint accounts for convenience. They moved and only one name ended up on housing documents. They stopped saving simple records because life felt normal again. 2 years later, they're struggling to find proof that should have been easy to keep as they went. Divorce during the conditional period makes things more complicated but does not automatically end status. There are waivers for people whose marriage began in good faith but ended. There are special protections for spouses who experienced abuse or extreme cruelty. In those cases, the immigrant spouse can often file on their own. These cases require extra care and solid proof, but they exist precisely so people are not trapped in dangerous or broken relationships because of immigration. Intent at the time of entry is also being looked at more closely in 2026. Fiancé visas have always required strong evidence that a real relationship exists, but now officers are paying even more attention to how often couples met, how long they've known each other, and how their communication has developed. For people who arrive in the U.S. on tourist, student, or work visas and later marry, the key question is what they intended when they entered. It's not inherently wrong to marry after coming on a temporary visa, but if officers believe that the person secretly planned all along to stay permanently and misrepresented their purpose at the border or in their visa application, that can trigger a finding of misrepresentation. That, in turn, can have serious consequences and is very difficult to undo. Timing is often what raises questions. How quickly marriage and filing followed entry, whether what was said at the consulate or the airport matches what happened afterward. Officers compare dates across travel records and applications to see whether the story holds together. For people who do consular processing abroad, there are additional risks if they've had any unlawful presence in the U.S. Leaving the country after certain periods of unlawful stay can trigger 3 or 10-year bars from returning. Waivers exist but are challenging and not guaranteed. Choosing the wrong path without understanding these rules can lead to long separations. All of this is why it's crucial to think strategically before you file, not just react after trouble appears. So, what can you realistically do right now? Start by documenting your relationship as it happens, not just as you prepare to file. Keep normal photos, not only pictures from big events. Save travel confirmations and tickets. Keep proof of cohabitation like leases and utilities. If you're long distance, keep a record of your messages and calls that shows how the relationship has grown over time. Be completely truthful on all forms and in every interview. Trying to hide a problem from the past almost always makes things worse when it comes out. Officers have access to data and records that most people don't see. Prepare for your interview together. Go back over what you submitted. Talk through your story and your daily life. You don't need to memorize lines, but you should both be comfortable explaining your relationship in a natural, detailed way. If you receive an RFE, don't ignore it or panic. Use it as a clear guide to what the officer feels is missing. Respond on time, directly, and in an organized way. Good responses can save a case that's on the fence. Keep building your evidence while your case is pending and after initial approval, especially through the conditional period. Continue to share responsibilities in ways that make sense for you and leave a paper trail. Don't assume you can stop keeping records after that first yes. Understand the financial sponsorship rules ahead of time. The sponsoring spouse has to meet specific income levels or use a suitable joint sponsor. Missing this can delay or derail an otherwise strong case. And know when getting a professional's help is worth it. Many straightforward cases can be handled without an attorney, but if you have obvious red flags, a history of immigration issues, any criminal matters, or if you're dealing with divorce or abuse during conditional status, an experienced lawyer can prevent mistakes that are extremely hard to fix later. Above all, treat your immigration case as a written and documented story of your shared life, not just a form-filling exercise. Officers are looking for a clear match between your narrative, your documents, and your actual circumstances. When those three line up, the process tends to be smoother. When they don't, everything takes longer and feels harder. Marriage-based green cards are still one of the primary legitimate paths to permanent residence in the U.S. Real couples are approved every day, but in the 2026 enforcement landscape, you need more awareness and more preparation than before. Love is the foundation of your relationship. Evidence is the foundation of your case. If this helped you see the process more clearly, make sure you're subscribed so you don't miss future updates as the rules and priorities continue to shift. And if you have questions or want a particular topic covered in more detail, leave a comment. I do read them, and they often shape what I talk about next. Immigration rules change. Enforcement priorities evolve. But preparation, honesty, and solid documentation will always be under your control. Stay informed, stay organized, and protect your future.